Good morning. Can I welcome everyone to this, the 24th meeting of the Justice Committee in 2012. Can I ask everyone to switch off mobile phones and other electronic devices completely, as the interview of the broadcasting system, even when they're switched to silent. No apologies have been received. Item 1 in the agenda, decision on taking business in private. The committee is invited to agree whether to consider items 4, 5 and 6 in private. Are we agreed?
No, Convener. Can I?
Yes,
I'd like
most certainly, of course.
Oppose item number 6 being taken in private for the reason that I think the committee's work programme is a matter of public interest and should be on the public record and therefore in the official report. And I'd like to oppose item 6 being taken in private.
Any comments from any other members?
That's obviously what we've been doing.
Could you put your microphone, please, to Mr. Campbell?
That's obviously a kind of change in practice from what we were doing up to now. So I think it probably merits more debate on the general point than just a kind of quick yes, no, no.
Can I just say that it's because we're maybe discussing the names of suggested witnesses, and if the committee were to out loud be commenting on whether or not they wish witnesses and so on for very good reasons, I don't think, in my view, it would be appropriate that that would be on public record. I also think it would inhibit discussion. There's nothing, I think, untoward about that, if I may say to the Deputy Convener. It's simply a free discussion of possible witnesses before the committee. I don't know what your views are on that.
Can we maybe deal with it later on and we'll deal with this part of the business and then come back to it later?
Yes, I'm certainly happy to defer and to move it into the agenda after we've taken evidence on the bill and we can discuss this matter. And that will be after a break when we can have a consideration of things. Thank you very much. Well, there we are. That's the way to start, isn't it? Unexpected. I now move on to item 2, the Scottish Civil Justice Council and Criminal Legal Aid Assistance Bill. This is our second evidence session on this bill, and today we are concentrating on part 1. Can I welcome the Right Honourable Lord Gill, Lord President and Lord Justice General to the meeting. The Lord President is accompanied by his Legal Secretary, Catherine McGregor. Can I invite you, Lord Gill, to make a short opening statement, please?
I'm very grateful to the committee for the opportunity to address the committee in relation to part 1 of this bill. We're just beginning a very remarkable process of legislative reform in Scotland, which will profoundly affect civil justice, I believe, for the benefit of the whole system. The Scottish Civil Courts Review was the first major exercise of its kind for over a century. The bill marks the first stage of the implementation of the recommendations of the review in legislation. During my career, I've seen many law reform projects run into the sand. But my colleagues and I, who were carried out the Civil Courts Review, we're gratified at the Scottish Government's positive response to our recommendations and to the prompt and committed way in which they have proceeded to implementation. As far as the present bill is concerned, in general, I'm entirely content with the terms of the draft. As far as I can see, they fully implement the recommendations in Chapter 15 of the report of the Civil Courts Review, and they are entirely in keeping with the spirit of those recommendations. And I think that the creation of this council will ensure that there is an integrated and systematic approach to keeping the civil court system under review in future, so that it can deal responsibly and flexibly with changing needs and problems as and when they emerge. So I see this bill as the first stage of a package of legislative reforms under the Making Justice Work project. The creation of this council will lay the foundation for the implementation of further projects, and it will be the vehicle for the whole implementation of all the legislative reforms that we have recommended. So I am pleased that this part of the programme has been devised in such a positive spirit, and I hope that the Scottish Government will continue to legislate in the same spirit at later stages of the programme of implementation. So I'd be very happy to answer any questions that the committee have in relation to part 1 of the bill.
Thank you very much, Lord Gill. Questions? David? Graham? David McClitchie.
Thank you very much. Good morning, Lord Gill. Inevitably, when you're setting up a new body, a lot of the questioning and representations that come to the committee is about who's going to be on it, who's going to be chair, and this is no exception. I think we have representations, for instance, from the Law Society suggesting that the influence of the solicitor branch of the, or representation of the solicitor branch of the profession is considerably reduced by comparison with the input which they have to the current rules councils which are being absorbed in this. And then equally we have other bodies like Scottish Women's Aid suggesting that there's insufficient representation from a user standpoint of people involved in family law issues, which obviously abuse may be a part of that. And then we have insurers suggesting that they are major users of the court system and that their input would be valuable in determining rules and procedures. So I wondered if you could comment on some of these omissions or apparent omissions that have been brought to our attention, and what you think generally of the proposals about the composition of this new body.
Well, I wouldn't see these as being omissions, because the use of that term would tend to suggest that these various interest groups would be excluded. And as far as I'm concerned, that's certainly not the case. It wouldn't be appropriate in primary legislation of this kind to be over-specific, where you would have a council of not more than 20 members, where you then itemised 20 different representatives of various interest groups. That deprives you of the sort of flexibility that's needed when you're setting up a council of this kind. As far as I can see, the list of people who, as it were, have to be on it is entirely appropriate, but then there is plenty of flexibility under paragraph D. There's a member appointed by the Scottish ministers. There'll be 2 persons known as consumer representative members who, if they comply with the requirements of paragraph H, and then there is a catch-all at the end where there are up to 6 members who can be appointed by the Lord President. And what will happen, as I envisage it, is that in the process of setting up the council, there will be an opportunity to consider exactly which spread of interest groups would be most appropriate. Could I just also say one other thing about this? There will be I envisage a process of publicly advertised appointments to the council. And my experience has been that when you advertise and invite applications, you tend to find that some remarkably suitable candidates emerge from quite unexpected quarters. So I don't think that at this stage you can say that any of the interest groups that Mr. McClitchie has mentioned will not be appropriately represented on the council.
Yes, I mean, do you have any ideas of the as to the sort of people that might be comprised in your 6-pack, which you'll be appointing when the body's set up? I mean, do you see them as representing user groups other than members of the legal profession? and that the balance between the legal profession representatives or members will be, in a sense, as is, and then there will be other user groups in the other 6.
I don't quite see it in that way. It would be quite wrong for me at this stage to have any hard and fast conclusions about who should be members of the 6 or the up to 6 people under paragraph I. But obviously, one would be looking to canvass the widest possible range of relevant interests. But at the end of the day, of course, a great deal of the work of this council is quite technical in the sense that it's involved in the drafting of rules. And in the early stages of the civil courts reforms, the drafting of rules will be quite a substantial project. And for that, you certainly do need strong legal representation on the council. But I entirely accept, of course, that it's desirable that as wide a range of interest groups, users of the system, should be represented, and I'm confident that they will be.
Content. Graham Pearson. Graham.
My question follows on from some of the points that David has alluded to there. There was a lot of conversation within the committee about LP members and what that meant. And I wondered, although you wouldn't want to, you've indicated you don't want to identify particular groups at this stage, out with the technical element of council, what kind of skills would you be looking for from people who might join you as a selected LP member?
Well, one would certainly be considering users of the system and the various interest groups who are involved in that. As you can see under paragraph H, the consumer representation is written into the bill. But in relation to your question, Mr. Pearson, about the LP6, I think the answer is that one would be looking for people with experience in business and commerce, economists, people like that. I'm not trying to tie my own hands at this stage, but you would be looking to the widest possible range of relevant skills. This council will obviously have to have budgets and have to plan and have to draw up some sort of corporate plan, and you would be looking for people who have experience of that as well.
And
could I just emphasise
sure.
that at this stage, my own consideration would exclude no one at this stage.
Yeah. It's a nice position to be in, I'm sure. There has been some concerns about the ability of lay members to have an influence within the council, given it will be heavily occupied by technical people who have a real understanding of the system. There was some comment that a layperson should either chair or at least be vice chair. What would your response to that kind of proposal be? How do you see that lay influence playing out in the council?
I don't think that it would be appropriate for this body to be chaired by a lay person, for the simple reason that much of the work will involve technical drafting questions, and for that you need, first of all, some experience of draftsmanship in the legal context, and in addition to that you also need some experience of how rules of court work in practice. And then thirdly, you also need to have the background to know when you have a genuine problem and what the appropriate ways are to resolve it. So I think that because of the vital priority of drafting rules, it's essential that this body should be chaired by an experienced lawyer, and I would intend to chair this myself to because I'm very keen to see that this gets away to a good start. It's critical to the overall implementation of the Civil Courts Review. And the recommendations of that review are obviously very dear to me.
You would accept, one would hope, that it will be important that the people who use the courts, the lay element that we've discussed earlier, that they should see a change in the culture, because there has been some disquiet at the lack of reform previously. So they want to see that influence brought through the council. Do you see that as an important part of the chair's responsibilities?
Absolutely. I mean, if you read my introduction to the report of the Civil Courts Review, you can't be in any doubt where my own sympathies lie and where what I would like to see from the civil justice system. But I've been only dealing at the moment with the questions of technical draftsmanship of rules. Another very important part of the Civil Justice Council's work will be the formulation of policy. What sort of system do we want to have? How do we want it to work? Whose interests do we want to protect? These are all matters of policy where lay input is absolutely vital.
Thank you.
You've touched on policy, accounting, because you've touched on policy. How does that match the fact that it's government ministers and Parliament at the end of the day, if they agree matters, if policy matters? How does that work with your relationship with government?
Well, it's not entirely a straightforward matter for government, because the rule-making powers, let's say, in the Court of Session are statutorily conferred by the Court of Session Act upon the court itself. So that rules are not imposed externally on the civil courts. It is the civil courts who devise their own rules in the light of their appreciation of current needs. And that will continue to be the case with the Civil Justice Council, because it will not be imposing rules upon the courts, it will be making recommendations. But it's obvious to me that the process by which those recommendations will be reached will involve input from the judges anyway, so I don't see that there's any risk of conflict in that matter.
John, you were down for, you want to supplement in this as well?
Yes, please, Convener, if I may. Morning, Lord Gill. Lord Gill, still on the question of the appointments process, there's a requirement in the legislation that you must prepare and publish a statement of appointment principle. Now, the committee has received a lot of evidence about the appointments process, and in particular the desire we would all have for it to be open and transparent. I wonder if that might be solved by that statement of appointed practice that you adopt being the Public Appointment Commissioner principles. And similarly, if I may, supplementary to that, a written procedure for removal of people from office. Again, that would cover the aspect of open and transparent governance. Yeah.
Well, under the bill, I'm required to prepare and publish a statement of appointment practice to set out the processes that will be followed for the appointment of the various members. I intend to draft a statement of appointment practice, which I intend to be based on the principles set out by the Office of the Commissioner for Public Appointments, and that will safeguard all the key principles of merit, fairness and openness, and that will be published.
Can I clarify, would that apply to removal from office as well?
The question of removal, I think, is rather a different one. I think that the appointment itself will set out what is expected of the members who are appointed by way of their commitment to the work and attendance at meetings and so on. And I think it's obviously essential that you appoint people who can be depended on to commit themselves fully to the work of the council, and that of course is part of the selection process. It's been my experience on various public bodies in which I've had the privilege of sitting in the past that it's seldom, if ever, that the question of a member's removal arises, because in my experience, people who do public service do it in a committed way. So I don't think that one needs to be too prescriptive about rules for removal and so on. But that's a matter that can be discussed in due course.
Jenny.
Thank you, Convener. Lord Gill, I wanted to bring you back to the issue of policy that you just touched on. I mean, this was something that jumped out at me in the bill, that civil justice policy should be the remit of government ministers and should be subject to the scrutiny of a democratically elected parliament. Can you perhaps expand on your definition of policy and what scope the new body would have in a policy remit?
You're absolutely right. As far as the justice policy goes, that's entirely a matter for this Parliament. And of course, the recommendations that are set out in the report of the Civil Courts Review make it very clear that the major proposals will require primary legislation, which is what we're about today. I was using policy in a rather different sense when I was speaking about the Rules Council. What happens is that when Parliament decides what the structure of the courts will be and what the remedies will be that the courts can grant, then it is for the Rules Committee really to decide at present how to make that work in practice, simply by the rules of court relating to time limits and what documents you must lodge and so on. These are all detailed matters of practice. And it was policy in relation to that I was talking about earlier.
Policy of the rules?
Yes.
Okay.
Yes.
So would you agree with me that perhaps the bill is a bit ambiguous to that extent and perhaps needs to be tightened up?
I don't think so. I think that it's very clear in Part 1 what the powers of the Council are in the draft of Section 3. And in Section 2, there are broad general statements as to what the functions of the Council are. And you'll see there that the Council is not just keeping the civil justice system under review and reviewing practice and procedure. It's also preparing and submitting draft procedure rules and giving advice and making recommendations to the Lord President on the development of and changes to the civil justice system. So I would envisage that in relation to that power, the Council might at some future time say, we should enlarge the jurisdiction of this court, or we should reduce the jurisdiction of that court, or we should transfer certain types of cases to the Sheriff Court and transfer others to the Court of Session. That would be the sort of thing that is envisaged under paragraph D. And I'm quite happy with that. I mean, I think that gives us a great deal of flexibility, but it enables the Council to not just to be buried in rules, as it were, but to stand back from the system and look and see how it can be improved. But at the end of the day, it's only making recommendations, because it's then for Parliament to decide if it will implement them.
Thank you.
Is this following on from that, or is this a supplementary?
It's to do with
I don't know what that means.
Yeah, well, yes. Morning, Lord Gill. You touched on this briefly already, but one or two people in submissions have sought to, or to seek to curtail the powers of the Court of Session to kind of take a view on any draft rules presented to them. I wonder if you could perhaps put a bit more flesh on how you see the operation of the draft rules produced by the new Council, and then paragraph 6, where they're then presented to the Court of Session for approval or rejection or amendment. How do you see that operating in practice?
I don't foresee the slightest difficulty in that. Here we have a council where there is a strong representation of judges and representation of the bar and representation of the solicitor profession. And then the various interest groups of which we talked about earlier on. So before a recommendation goes from the Council to the Court of Session in
I think I'll perhaps just say, I wonder if it would be useful, because I think you're still in the faculty.
Declared my interest as a member of the faculty.
Just to make him, you know, belt and braces that he may have an interest.
Well,
you're very naughty. We've missed you. Where's Mr. Leclerc to behave? Right, sorry.
So to return to where I was, what I was trying to say was that by the time a recommendation emerges from the Council, it will have gone through extensive discussion by people on the Council who have considerable knowledge and experience of this. There have been strong judicial input into it, and the likelihood that a recommendation that then emerged from the Council would be rejected by the courts seems to me to be remote in the extreme. But the language of recommendation has to be used for the technical reason that under the Court of Session Act, it's the court that makes the rules.
Thank you for that. I apologise for the interruption there. We're getting quick, but we're just come back. Heads are not together yet. Mine isn't anyway. Hamza, you've been very patient. Which is unusual, but there you go.
Yes, I know. Thank you, Convener. Good morning. Really, I just wanted to go to a more specific issue about alternative dispute resolution, ADR. I just wondered if you could comment on, largely it's got from the written submissions that we've had, it's largely got a positive write-up and a positive welcome. But I wondered, one or two organisations have raised concerns about the idea that it should be promoted where appropriate, and what that where appropriate caveat might mean. In particular, Scottish Women's Aid made the point that family law cases involving domestic abuse may well be swept into this caveat. I just wondered if you had any reassurances that you could give on that.
The question of ADR was specifically considered in the report of the review, and we came to the view for a number of reasons that I needn't go into in detail today. We came to the view that to make ADR compulsory in the civil justice system was wrong, and that everyone should have the right of recourse to the courts. But we also recognised that in many cases ADR is the ideal method of resolving a dispute. There are some cases, as you know, that would never be appropriate for ADR, but there are also some cases, in my experience, that are never quite appropriate for the courts. And as long as you have that option, and as long as facilities are made available for ADR, then I think one has to leave the choice of that to the professional advisors and to the litigants. But I can't see that there is any obstacle in the way of ADR in any of these proposals.
I imagine we'll pursue.
I think Hampstead will help. For the record, you said what ADR was, alternative dispute resolution. Yes, because other people.
Sorry, I thought I said that.
Who are not, perhaps not. Perhaps not. Sorry.
I can understand exactly what you're saying, Lord Gill, but I wonder if those that have been involved in a domestic abuse case before would say actually the courts, legal profession really hasn't dealt with these cases as best as they could have or should have, and actually they welcomed the reforms and the report for precisely the reason that it might enforce a culture change, if nothing else. And so then maybe you can expand upon how exactly that where appropriate caveat is determined and how it is determined. Is it just through solicitors? Is it done through advocates? Done through the litigants themselves? In which case you could see exactly where their concerns are.
No, I think unless you have a rigid rule that every dispute that comes before the court must be subject to ADR in the first instance, and that's a possible way to approach it. Unless you'd go down that route, then the only other way is by the encouragement of ADR by first of all, the encouragement of it by the court itself, and by providing the facilities for ADR, should the parties wish to resort to it. We were quite keen in our report to ensure that there should be facilities for ADR in the courts, and I can't see that there is anything in these proposals that would in any way inhibit that. It could be, of course, that in due course the Civil Justice Council itself would recommend rules that perhaps provided for the consideration of ADR at an early stage in the resolution of a dispute.
Yes, a lot of what you say is perfectly logical, but I wonder if whether or not maybe the cultural change then has to come from lawyers and solicitors. I mean, some of the evidence that we got from Scottish Women's Aid, again in particular, about lawyers suggesting, mainly to women, that if they didn't take part in some kind of resolution mechanism, dispute resolution mechanism, then they would be seen as, they suggested they would be unreasonable, obstructive, maybe even hostile by the courts if they chose not to go down that route. Do you think your reforms deal with that?
I'm not aware of that as being a problem. And
okay, but it's being said it is a problem by Scottish Women's Aid. So.
Yeah. Well, all I can say is that the hope would be that when the recommendations of the review are fully implemented, that there will be a huge culture change, and that people will look at the legal system and the civil justice system in an entirely new light. That would be my hope, because these reforms are quite radical, and they should alter the climate in which disputes are resolved.
Thank you. I'm going to move now to Jenny. You had a question, and then I'm taking Colin, and then Rod, are you still wanting to come back in? Not at the moment. So Jenny, then Colin.
Thank you, Convener. Lord Gill, I just wanted to explore this point. I understand that the Scottish Civil Justice Council will be funded by increased court fees from civil cases. Is that correct?
That's the intention, yes.
And with the change in the threshold for civil cases going to the Court of Session, with the new £150,000 threshold, a lot more cases will be heard in the Sheriff Courts. I think thousands, it's been estimated, more cases will be heard in the Sheriff Court every year. With that larger number of cases, do you feel that the Scottish Civil Justice Council will be able to be properly funded if Sheriff Courts around Scotland were to close?
Well, I think that you're absolutely right, though, in that there will be a very substantial transfer of business from the Court of Session to the Sheriff Court. There's no doubt about that. That's the intention of the proposals. I don't think that it follows that the court fee income on which will fund this council will necessarily be less. We're providing a specialist national personal injuries court. There will obviously have to be a review of the fee charging in relation to that. And then I think also when Sheriff Principal Taylor's report on litigation funding is published, which I expect to be fairly soon, that I think will necessitate a complete review of the whole question of court fees and the amount of them. So I don't at this stage, I'm not prepared to assume that the income from court fees will be any less as a result of the changes in jurisdiction.
Will there be a charge for all civil cases, despite whether it's heard in the Court of Session or in the Sheriff Court, and that will go towards the funding?
That's the expectation.
Okay,
yes.
Thank you.
It's interesting. I don't know, Lord Gill, you can't really comment, but I notice on the Legal Aid Board's submission they don't mention this because they will carry in many cases the cost of the increase of those fees. It will carry it. in legal aid funded cases.
Yeah, I'm not fully conversant with how the system actually works in relation to legal aid, because there have been so many changes to it over the years.
I just remark on it in that we've got the vote coming before us, which is interesting because, having said that, you know, that unless there's an award of expenses for the legal aid funded party, then the board will be meeting the cost of those. Now, I note they've not put anything in their submission about additional costs to legal aid, but I just put that on the record so that the legal aid board might answer it. I now move. Sorry, Jenny, have you concluded? I'll move on to Colin, please. Colin,
thank you. Good morning, Lord Gill. My questions actually are based on a comment that's been brought in by the written submission from Citizens Advice Scotland, and it's in relation to the role of Lord President. And the Citizens Advice Scotland reckon that there should be a clear separation of the roles between the Lord President and the Council to obviously ensure impartiality. Could you, have you seen, I don't know if you've seen the actual submission, but it's effectively saying there could be a conflict of interest one way or the other. Perhaps you could give us your comments on that.
Well, I can see where the origins of that objection are, because if you turn to section 2, D and E, to 1D and E, you'll see that one of the functions of the Council is to provide advice and to make recommendations to the Lord President. And then in relation to E, the other function is to provide advice on any matter relating to civil justice as may be requested by the Lord President. So I think that the fear that's expressed in that objection is completely overstated. The role of the Lord President is at the heart of the rule-making function of the Council, and I think that makes it entirely appropriate that the Lord President should chair the Council. At the end of the day, though, the Council have a mind of their own, and if the Council take a view about a matter in which they wish to make recommendations to the Lord President, the fact that the Lord President is the chairman of the Council doesn't seem to me to bring us into any situation of conflict. On the contrary, I would have thought that the Lord President would be listening very carefully to the sort of recommendations that would come from a body like this. Can I just say also, Madam Chairman, that at the moment, I currently chair the Civil Courts Rules Council and the Criminal Rules Council, and they, at the moment, do have that function of providing advice to the Lord President. It doesn't cause the slightest problem in practice.
Hamza, supplementary?
Yes, just to that point, I mean, not every Lord President, perhaps, I would suggest, would be as willing to listen to advice as perhaps yourself or maybe other potential candidates that are out there. And I think maybe expanding on Colin's point, does there need to be something further within the bill, the face of the bill, to dampen that perhaps conflict of interest, or indeed make more checks and balances to the position of Lord President as it currently is?
No, honestly, I wouldn't be worried about that in the least. In fact, I think there would be greater cause for concern if I wasn't chairing this council, because in that case there would be a very strong possibility that the council and the Lord President could take divergent views on some important matter. My view is that if the council has deliberated on something under the chairmanship of the Lord President and has reached certain conclusions, then a wise Lord President would be listening to what they're saying and learning from the sort of collective wisdom of the council on the point. So I honestly, I don't see this as a major difficulty at all.
Alison McInnes.
Lord Gill, can we take a moment to explore the issue of administrative justice? The policy memorandum proposes that the new council will take over at least some of the responsibilities that are currently carried out by the Scottish Committee of the Administrative Justice and Tribunals Council, and yet the bill itself doesn't actually contain any provisions in relation to that particular role. Do you feel that that needs to be explained on the face of the bill?
Well, I don't think really this is the correct moment in history to be making to be drafting legislation in relation to the administrative justice side of the justice system in view of the uncertain state of the future structure of tribunals in Scotland and the question of resources. I would favour taking one step at a time, and I think that the remit of the Council should be restricted to what we see in the bill for the time being. If you want my own opinion, ultimately, I think that the remit of the Council will be extended to include administrative justice and tribunals. But I think that it would be premature for us to be legislating about that at this particular stage.
And perhaps just following that up, recognising what you're saying about it being premature, nevertheless, if it were to come to pass, do you feel that the new council would actually be able to balance all those responsibilities properly? You spoke earlier about the very heavy workload that you're going to have in the initial years in terms of writing the new rules and things like that.
That I think is the reason why we should keep the council to a fairly restricted remit at the present time. There is a very considerable cause for concern that if the council were given far too big a remit, it would be overstretched financially and administratively at an early stage, and its resources would be spread too thinly. So I'm rather keen to see the council get away to a good start on a very clear and defined remit, and I do not exclude the possibility of its being extended in due course. In fact, as I've said, I would support the idea.
I see no further questions. I take it no further questions from members. Now, thank you very much for Lord Gill for your attendance, and I'm going to suspend for 8 minutes. We'll move on to the next panel of witnesses precisely. Back in session, and I can't count because I was taking us up to 11 o'clock, which is far too long for MD to have a break. And I now move on to the next panel of witnesses. I welcome the second panel. I think you were all present at the previous evidence session. I have Lauren Wood, Social Policy Coordinator of Citizens Advice Scotland, Ronnie Conway, Civil Justice Committee, the Law Society of Scotland, Richard Henderson, Chair of the Scottish Committee of Administrative Justice and Tribunals Council, and Louise Johnson, National Worker at Legal Issues, Scottish Women's Aid. And can I thank you all for your written submissions, and we will go straight to questions. And can I say to witnesses, obviously, if a question is directed specifically at you, the microphone will come on automatically. If you wish to come in, whether it's not directed to you specifically or as a supplementary, if you just indicate to me as the chair, I'll call you and again, you don't need to press anything. It's technologically perfect in here. I hope everybody's hearing that. And the light will come on and your microphone will immediately be activated. Right, questions, please. To the committee. Rod, yes.
Perhaps morning panel. Perhaps I could kick off by just asking the Law Society for some comments on my assessment of the situation in relation to the cost of collection of summary legal aid. My understanding is that summary legal aid is about 35 million. The government estimate that under the new proposals, about 80% of... Is it?
Wait.
Am I not being
I just want to tell you, Rod Campbell, that the Law Society, that's why you're looking a little bit discombobulated there. The Law Society is coming back next week to deal with part 2, so we're on part 1.
Sorry, right.
Okay. Your moment will come next week. Yeah. Is it next week?
Next week.
There we are. So, we move on to that. Jenny?
Now convene. Thank you.
Yes, absolutely.
Can I ask you all, the current 2 Rules Councils deal with a large number of very technical procedures. So how do you feel the proposed structure and membership of the new council will be able to handle these changes? So it's really about technical expertise.
Mr. Conway.
Can I say that in particular, first of all, thank you for the invitation to address the committee this morning. This is a concern which the Law Society has. Both the Sheriff Court Rules Council and the Rules Council in the Court of Session are being abolished and replaced by the Civil Justice Council. I understand that there are concerns about the numbers of lawyers who might be on the Civil Justice Council, but I think before we look at what we're getting, we've got to think about what we are replacing. I was a Rules Council member in the Sheriff Court for 3 sessions, a total of 9 years. And if I may say that the kind of work which a Rules Council does is this. There is primary legislation passed, either here or in Westminster. That has to be integrated into the existing civil court rules. You get a pile of papers from the draftsperson, you get proposals, there is a meeting, the proposals are nitpicked, quibbled over, the detail is mind-numbing. Even for a lawyer, it is one of the most boring jobs which I did in my career. If I can just give you a taste of it, these are the Sheriff Court rules, which are 900 pages long. These are the rules of the Court of Session, which are 2,500 pages long. And I fully agree with Lord Gill's proposal that these rules should be harmonised. I fully agree that they should be written in English, which all of us can understand.
You mean lawyers don't understand the rules? This is breaking news for the Law Society.
I couldn't possibly agree with that proposition, but from time to time, the rules are impenetrable even to lawyers, it seems to me. And the point I'm trying to make is that this is a mammoth task which the Lord President has set himself, because as well as reform, the Civil Justice Council is going to have to do all the things which the Rules Council do at present. And it seems to me the Law Society submission is that for the next 5 years at least, this is a job for technicians. And we think that the proposed make-up of the committee is light on technicians. And at the risk of offending the Lord President, it appears to me that there are too many judges on the committee and that we could lose a member of the Faculty of Advocates as well. Sorry, Mr. Campbell. The reason I say this is that it's all very well talking about justice being accessible, efficient and fair, but these kind of reforms, the key is in the minute particulars. It's in the minute particulars. And the persons who know about this are the persons who are doing it day in, day out. That you learn from the grind of representation and casework. And the proposal, in the written submissions, the Law Society asked for 6. Instead of 2 members, they asked for 6. Having considered matters, and I think have to recognise the disquiet or unease that this might turn into a council with lawyers talking to themselves about themselves. The proposal or the suggestion today is that there should be 4 Law Society members. And if I may be allowed to expand on that, these should be drawn from the specialist parts of the profession. And that's where they have the advantage over a Court of Session judge or a sheriff or a member of the Faculty of Advocates. And the particular proposals which I would suggest would be these, that we should have, first of all, a member from the claimant side of the profession for personal injury work. We should have a member from the defender side of the profession for personal injury work, which takes up a huge mass of the work of the courts at present. That would also meet the requirement or the suggestion that insurers should be represented somehow on the council. There should be a family law representative and there should be a commercial practice representative. And I think without those placements, I just wonder how the detail of the rules is going to be properly written.
Just to challenge you, are there not members of the faculty who specialise, as do solicitors?
There are some members of the faculty who specialise. There's no suggestion in in anything that's in the bill or anything that I heard from Lord Gill today that persons other than generalists will be appointed.
Ms Wood.
Again, thank you for asking us to come and give a submission today. To pick up a little bit on some of the points that Ronnie's made, I think that there will be a lot of change in all aspects of the civil justice system, particularly over the next 5 years. And while, yes, the rules will have to be drafted, there will also be change that has to be monitored on the implementation of the Making Justice Work programme, not just in terms of the technicalities of that, but how that has impacted on the professionals who sit in courts as part of the Making Justice Work programme, how alternative dispute resolution and administrative justice have changed as part of the Making Justice Work programme, and how users are accessing the system differently after 5 years of implementation. And so I think to see the council as a body who is to cope with all of these things at the same time is perhaps slightly unrealistic, and perhaps the way to get around that and to actually make the fullest use of the council is to use committees and subcommittees to deal with varying aspects of the changes to the landscape, like the rules, like how users are accessing it, like how judges are accessing the new system, and like how alternative dispute resolution sits in, and to use the council as more of a facilitator to listen to those committees and subcommittees.
Is that not possible under section 13(1)?
I think it is possible, and I think in our submission we do welcome the fact that there are committees and subcommittees, but I would say it's difficult in discussions about who is going to be on the council because there are so many competing interests. I think at 20 the council is probably at the maximum number that it should be. I think any more people and there are too many different interests to be represented. So perhaps to make the council function as effectively as possible, one way would be to utilise Section 13(1) and to use committees and subcommittees to achieve the very technical detail that has to be achieved when it comes to rules drafting, to achieve policy functions and to achieve research functions that we see as being an encompassing part of the changing civil justice landscape.
I mean, I'm sorry, I think that's quite possible under the bill, because you don't have to have 20 people there. Lord President, Section 12(1), Lord President may determine the number of members required to constitute a quorum. So we've got that, and then there's also the elasticity to have subcommittees and other committees. Is that not?
I suppose the point I'm trying to make is, in arguing for extra members, one thing to remember would be the opportunity to have committees and subcommittees. So the extra members may not need to be appointed for the longevity of the council. You know, if we think of the council as a body to last for the next 20, 30, 40 years, then perhaps extra members to deal with the initial technical details don't have to be appointed as a legislative part of the bill, but can be thought of as going into subcommittees.
Thank you. Yes, sorry, Ms Johnson.
Yes, good morning, convener and committee members, and we appreciate the opportunity to speak to you. In relation to the technical side of the committee, the Civil Justice Council, the Council is not just there to produce rules. Its functions are also to keep the civil justice system under review, that's Section 2, to provide advice and make recommendations to the Lord President on development and changes to the civil justice system. And one of the powers is to provide advice and make recommendations to Scottish ministers on the development of and changes to the civil justice system. And Lord Gill has just said himself that the Council will lay the foundation, I hope I'm quoting him correctly, for other projects and will be the vehicle for all legislative reform to be implemented under the Gill Review, etc., making justice work. So it's not just rules. And in terms of the rules themselves, there is a concern currently that the rules are far too technical. And really the courts and the processes should be accessible without being obviously overly simplified. And so there certainly is merit on having, as colleagues said, individual subcommittees to deal with this. However, the overall membership must be able to reflect the court users. There is no point in having rules or processes or references to legislation or changes that, one, do not actually take the needs and rights of court users into account, and secondly, they haven't been consulted on. So I think just looking at it as a vehicle which is just going to be solely looking at very technical aspects, I think narrows it. It's certainly much broader than that, and in the circumstances we would certainly be pushing for a broader membership.
Mr Henderson, do you wish to come in here? Or?
Well, I find myself in a somewhat difficult position because, of course, we're here because of what's not in the bill rather than what is in the bill, and the consequences of it not being in the bill, but the possibility of it becoming part of the bill, means that you're looking at the whole structure and nature of administrative justice to see how you absorb that actually into a structure which is primarily dealing with civil justice. And if the civil justice element is reduced down, if I may put it that way, to rulemaking, then the probability of the council being structured in a way which is appropriate to allow for the broadening of bringing in administrative justice is actually very much more difficult.
I think, though, you accept the Lord Gill's main point about the constitutional issues that are in the air that perhaps impact on practice in your area.
There are many balls in the air just now, some of which may come down to land fairly soon, as long as they don't hit me.
Well, I don't know what would hit you there. Jenny Mara.
Thank you, convener. I think it's an interesting discussion about the membership, but Mr Conway, if you'd allow me to play devil's advocate for a minute, you were talking about the technical expertise, and I completely appreciate that. This is complicated stuff, and you held up the books of rules, but can I put to you that if you've got a council completely comprised of lawyers, then the rules are actually going to be less likely to be comprehensible to the lay person.
I think you heard the Lord President. I think there is no prospect that this council will be completely comprised of lawyers.
The extra ones you were mooting.
I'm looking to shove people out of the balloon, so to speak. I think I don't quibble with the number of lawyers proposed in the bill. What I see is the makeup should be different to reflect specialties.
Mm-hmm.
If I can just pick up what Lawrence, sorry.
Can I come back on that?
Yes.
Would it be possible, because of the concerns, to perhaps have people who are not maybe necessarily practicing law in that area, but you cited the examples of insurers or family practitioners, people with experience, legal experience or qualifications in those areas, and that are perhaps working in different fields now to be part of that council, rather than practitioners themselves?
It comes back to what's going to happen over the next 5 years. And may I say that if this committee were to take place 5 years from now, the answers might be rather different. But the reality is this. And if I can perhaps deal with something that Louise spoke about policy, etc. As the Lord President indicated, policy, first of all, comes from the government. Secondly, the scope for huge... we are not starting from a blank sheet of paper here. We have the Gill Review, and whatever one thinks of the minutiae of it, it is a tour de force. It is a tribute to the Lord President's power of analysis. It is what he wants to have done over the next 5 years. And what we are talking about are mechanisms which will ensure that that is done for the benefit of the people of Scotland. And a huge element of that relates to the rules. So I actually, before I came here, I wondered, would the Lord President say, well, you could outsource rules to a rules committee, which is what happens in England. In England, you have a Civil Justice Council and you have a Civil Procedure Rules Committee as well. But for reasons of economy, I think it says in the Gill Review, everything has to be lumped in. But it appears to me the single critical matter with which this council will have to, it will be implementing what I've said already about harmonisation, simplification, etc. It will be dealing with all the new stuff. It will also have to integrate the Gill reforms into rules which are workable. And of course lawyers have a vested interest in this area, but the vested interest they have is that a system of rules is workable for clients and for the people of Scotland. And it's such a central point that I do not think it would be appropriate, for example, to outsource rules to a subcommittee, then to be handed up to a Civil Justice Council who will not have the necessary technical know-how. It's a question of nuts and bolts.
Can I take you back to, I think, please forgive me if I'm summarising this wrongly, but too many judges and too many advocates, I think, was your line. Now, you know, there are practising solicitors who instruct counsel, and those solicitors do understand the rules of the Court of Session, as well as the Sheriff Court rules. But there are lawyers practising in areas where they don't know the Court of Session rules, and they are different, similar in many ways, but they are different. What is the problem about having that balance of the practising advocates, who would be much more au fait with the Court of Session rules, and the practising solicitors more au fait with the Sheriff Court rules, and also, and I'm looking at 6, the composition of the council, one judge of the Court of Session and a sheriff principal or sheriff. Day to day, I mean, rules are just like, I don't know, the carpenter's tools. You know what to apply at certain times, and you know if you've applied the wrong thing. Having practiced for years, you've got to know the rules, because they can get you in the soup if you don't. So what is the problem with that? It strikes me that this is a kind of having been a solicitor in my time who instructed faculty, and I will say for the faculty to defend them, there are specialists. You go to certain advocates for certain things, commercial or family or delictual actions or whatever, reparation. That seems to me a reasonable balance of the technicians, as it were, the people who have to know to apply the tools, which are the rules.
Well, I think what I would say is, just to use your analogy, Madam Convener, a carpenter will probably know how to make one kind of thing. We are talking about, in my suggestion, a number of different kinds of things. And the main areas, as I indicated, are personal injury, family, and commercial. And there are, I would be hard-pressed to identify, there are certainly advocates who are specialists. There's absolutely no doubt about that. But insofar as dealing with the day-to-day business, the grind of casework, so to speak, then it's my suggestion that solicitors have an unparalleled level of experience and expertise. Just now, as far as the constitution of the current Rules Council is concerned, there are 5 solicitors on the Sheriff Court Rules Council and 5 solicitors on the Court of Session Rules Council. So this is a change, so to speak, in favour of certainly the faculty of advocates.
I didn't think I'd be defending the faculty so robustly, but I'm afraid I have to challenge you that, you know, when we're looking at the balance here, I really cannot see how having 2 practising advocates and 2 practising solicitors on it is not a balance in these circumstances when you also have a Court of Session judge and a sheriff principal or a sheriff, all very familiar with their own territories. They also know the other territories, but, you know, to suggest for some instance that, you know, that faculty have not got specialists in it or don't have specialist knowledge of the Court of Session rules, and conversely solicitors of sheriff court procedure is really quite wrong, if I may say to you, because I certainly have had advocates in my time not sometimes aware of certain things in sheriff court procedure, and vice versa. A lawyer not being aware, especially an out-of-town, out of Edinburgh lawyer, maybe not aware of Court of Session rules that they have to keep their eye on along with the faculty. So I thought that was a reasonable balance, frankly.
It's a question of how the committee is described and who's invited. As I say, it's my suggestion that the solicitor's profession is underrepresented, and that a better balance would be to have 4 solicitors representing those particular specialties. The point I made, for example, about the personal injury bar, there is no member of faculty who considers themselves to represent the pursuers or the defenders, whereas there are organisations which exist which would represent claimants and which would represent defenders. And that would be an easy way of getting those interests direct into the council.
I don't want to dispute and dominate this. I disagree with you quite fundamentally about some of the stuff you just said, that Rod Campbell.
I'm still a bit troubled. Obviously, you talked about various specialisms for solicitors, but what's to stop, for example, a subcommittee kind of specialising, looking at kind of personal injury practice, personal injury rules, having a big complement on that subcommittee of practising solicitors of the type you described, pursuers and defenders? Why can they not contribute on a subcommittee basis?
Well, as I say, I had expected to hear the Lord President say that when he came along today, but there's no suggestion of that subcommittees would be formed in those ways. It would be one way of addressing it, but you've then still got the difficulty that it goes to the rules-making body, and you have generalists on the body who don't really know what they're signing off. That's really what I'm saying.
Graham Pearson.
Thanks, Convener. I don't presuppose what the answer is going to be to this question, but as someone who is spectating on this conversation, I wonder if Lord Gill in his review identified 206 recommendations for improving the administration of civil justice, in spite of the tomes that you have in front of you. Is it perhaps a case that this council will have an actual function of changing the experience of the customer, the client group, rather than engage in the technicalities of people involved as the technicians within the system, and hence not quite the same focus on your rule book and more about trying to draw the outcome to council so that they understand whether or not the system actually works. Is that not really the function as council, rather than rewriting your book?
Well, I'm repeating what's said in the Act, Mr. Pearson. That's what one of the things the council is tasked with. But the idea that the rules somehow are just technical matters and don't impinge on the customer experience is not correct. As I say, it's easy to make rhetorical statements about justice should be fair, accessible, free for all, etc. But it's only once you get down to the minutiae, to the minute particulars, that either does, that promise is either kept or is broken. So the rules in my submission are of critical importance. But you're quite right. You heard Lord Gill say that he hoped there would be a culture change. And of course, if I can raise just slightly 2 cheers for the civil justice system which we have at present, not everything that Lord Gill said in the Gill Review was critical of the justice system. There have been 2 recent reviews. First of all, the Elaine Samuel review of personal injury procedure in the Court of Session, where the results were the best report card which any justice system could ever get. We had the review of the Glasgow Commercial Court system, where, again by Elaine Samuels, who's a well-known government researcher, with the same result. The challenge is not to replace, as far as personal injury is concerned, not to replace that, but to replicate it in a different forum, in the Sheriff Court. So you're going to have this massive downshift of work from the Court of Session to the Sheriff Court. In the Sheriff Court, in some respects, it's counterintuitive, because the Sheriff Court is where the problems are just now. They don't have the resources. The work is log-jammed. There's a culture of delay, adjournment, etc. The idea then is that gets downshifted again to the work of summary sheriffs. Now, that's a massive undertaking. And for what it's worth, I think Lord Gill is entitled to expect as much assistance from the people around here and from the legal profession to make that work. But that would be the change in culture and the improvement for the customer, which the Civil Justice Council one would hope achieve.
Convener, could I possibly?
Yes, of course. Yes.
Just interestingly, following on your comment about change of culture, one of the concerns that we have certainly is the focus on the work of the council in relation to almost commercial, personal injury, consumer issues, nothing about family. Now, given the fact that there has just been a major case decided by the UK Supreme Court, the B versus G case, as it's colloquially referred to, and I can give you the full citation for that, which in which Lord Reid criticised the culture and the way that I think the Scottish civil system actually approached the whole issue of family and child welfare. And currently, the Sheriff Court Rules Council is looking at child welfare hearings and is tasked to continue with that. There will be very much an emphasis on looking at the procedures of family law, not just the rules. The Gill Review covered things like bar reporters, case management by the judiciary, hearings, agreeing evidence, matters which are not strictly technically rules but are procedural but would actually affect court users. So firstly, you have to have, whatever spread you have here, solicitors, as my colleague Ronnie said, who are cognisant with the day-to-day runnings of the Sheriff Courts, especially if there's a move to bringing down business from the Court of Session to the summary sheriff. Now, the summary sheriffs, it's suggested, would deal with child welfare hearings, which we completely opposed, because we see that as I think, a deprioritising of cases involving children. But regardless, you're going to have, within the sheriff gambit, as it were, be it sheriff courts or sheriff summary, a lot more business involving children, family, etc. So whatever you have in there, you have to have professionals who are cognisant with that, with the changes, how to affect them, judiciary, be the Court of Session or sheriffs who are able to get to grips with that, and also representatives from organisations. I'm not just saying us. I'd like to be this very clear, but representatives of court users for family issues. And that's one of the major concerns that we had on the proposals, that it seems to be very much loaded towards, say, consumer, personal injury, etc., and family, which is a major part of the business and is an incredibly important part when you're looking at the welfare of children, should be prioritised, and any changes to that must include user involvement.
Yes, Ms Wood.
Going back to the point that that Mr Pearson made, in our submission, I think the phrase that we used was, we see this body as taking strategic oversight of the civil justice system as a whole, for end users, for practitioners, and for the system as it functions and interacts with each other. The experience of end users is for us of ultimate importance, but that is dependent on the experience of the practitioners, be it judges and lawyers within that system, and also dependent on the interaction of different tiers of the legal system. The Gill Review and the Making Justice Work programme see alternative dispute resolution as playing a bigger and bigger role as part of the civil justice system. And it's our submission that from the outset of the Civil Justice Council, that should be considered. So in terms of looking at the civil justice system, we shouldn't just be looking at the Court of Session, the Sheriff Courts. We should also be looking at administrative justice and alternative dispute resolution, and how they fit together, and how the experience of practitioners then impacts on end users. I mean, the rules are certainly very important for that, but the culture shift is equally very, very important. We also see the Council as not just taking an oversight of how things change as the Gill Reviews and Making Justice Work programme are implemented, but it having a vital role in a sustainable civil justice system. And as a sustainable civil justice system, I think it is important to look at the Council as being a thing of longevity. So yeah, we would certainly see the role of the Council as not just having a rules function, but as looking at the whole system as it relates to every person who's likely to participate in the system, and also looking at that system for the long haul.
Yes, Mr Henderson.
Once again, I'm slightly hesitant about entering into this debate, because what I'm talking about is simply a possibility. But if you begin to talk about administrative justice and tribunals being brought within the purview of a Civil Justice Council, you have to ask yourself, what is it that you're bringing in? Because administrative justice and tribunals are dealt with separately. Civil justice is seen, especially in this context, as civil courts, civil court reform, and you're down as far as rulemaking. If you bring in administrative justice and tribunals, and you bring in administrative justice, then you're dealing with an area of policy making which is quite separate and distinct from civil justice policy making. Administrative justice exists in the context of the citizen and the state in their disputes, tribunals. If you're looking at the work that the current committee and current council do in the policy that they're doing, for example, they're looking at the principles that should underlie administrative justice. The Scottish Committee published yesterday a report on appeal decisions for which there's no appeal. In other words, looking at things like housing, community care, and such like, where decisions are taken by government or government agencies for which there is no appeal open to the citizen. Now, that is a pretty sensitive area of policy work. And what you have to ask yourself is, how appropriate would it be for that type of policy work to go into a Civil Justice Council, which at this stage would be starting out looking at issues of civil court rules? But is it appropriate, or is it likely that you would get the end result you might be looking for in a body which is composed principally of lawyers?
I'm going to Rod Campbell.
Just briefly, if I may, just following on from a point that Lauren Wood made, and really for the record, Louise Johnson, you were referring to the Supreme Court case. I think perhaps it's important to stress that one of Lord Reid's comments was that it's rather easier to change the rules of the court than to change a prevailing culture. Would you agree with that comment?
Not necessarily. You can change rules, but it doesn't mean that people will follow them. And one of the comments I made at a seminar that was actually held last Friday, the Murray Stable of Advocates and Scottish Child Law Centre had a discussion session on those very issues. And we came to the conclusion that what was not actually needed was change in rules, but actually a change in, say, training attitude. Now, rules are there to be followed, but they can only be followed if you have the culture to actually follow them. So you can create all the rules you like, but if people don't want to follow them, there's no point in that. And the change in attitude, I think, is the more important one. Because, as I actually said there, there's no point reinventing the wheel. We have a wheel. What we need to do is work with what we've got. And the issue, certainly I think before, in terms of B versus G or with the Scottish Civil Justice Council, is ensuring that the processes are fit for purpose, but also that people get the best out of their interaction with the civil court system. So it's not just a case of rules. Certainly I said you can have all the rules you like, but if the culture isn't there, and the culture does have to change. You can't have a reform to a system without a change in mindset. And some of those changes are actually have been sort of put forward by Lord Gill in terms of judicial case management, etc. And that's not necessarily just rules. That's of thinking about how process actually works. Does that make sense? You're not convinced?
You are agreeing with Lord Reid, but
well, yes and no. It's not just a case of producing rules, because as I said, if you have rules and people don't want to follow them, then that's entirely inconsequential. But if you actually have an overall mindset that wants to follow the process, then that's the way forward. And it's not just a question of mindset on its own. You have to have the processes to follow them. The processes to follow to almost get that change in place. And I think the problem just now is the way that some of these cases are actually dealt with. That means the rules themselves aren't right. So therefore you have the mindset that people aren't following them for whatever reason, or they're not working for court users. For instance, I've heard a lot of comment that Form F9 for children, taking children's views, is really not a very good a very good facility for children. So we have a rule. We might have a mindset about changing how to use it, but unless people understand why they have to change in the first place.
I think between following rules and rules not being appropriate, because I think that any solicitor or advocate who didn't follow the court rules would soon find the judge or the sheriff telling them something. But I do follow your argument. I think it's you're saying that the rules don't always act in the interests of fair process and justice.
Yes,
rather than them not being tempered by the lawyer or the advocate.
Yes, it's a case of not being not that they're not being obtempered, but they're not being really applied in the spirit of which they're intended.
Yeah.
That I think is the problem, and also perhaps being too complex or too difficult in their construction for the issue that they're trying to achieve.
Yes.
So therefore, the whole issue is, can we look first of all to make sure that the processes are simplified, but also you have to have the mindset that wants the processes to be simplified in the first place.
As distinct from saying that people don't follow the court rules, which would be
inappropriate. Which is a
I got there before you, Mr. Conway, you see. I'm going to slip back into previous profession. I mustn't do it. Ms. Wood.
I think certainly there does have to be a culture change, even if there is a rules change. We mentioned in the submission the Citizens Advice in Court mediation service that works in Edinburgh Sheriff Court, and I have to admit I noticed a mistake this morning when I was reading it over again, so I will submit an amendment. The sheriffs don't send on 90% of the civil business because that would be overwhelming. They send on 90% of the small claims business in Edinburgh Sheriff Court to the mediation service. And of those submissions, over 80% of the cases are resolved through mediation very quickly, often within an hour. The mediation project has been going for 10 years, maybe just slightly under, and the number of referrals, if you track them over the last 10 years, marks a significant culture change. But it does take a long time for change in culture to filter down through the system. So now the sheriffs in Edinburgh Sheriff Court are very open to the process of mediation. They're very open to referrals to the mediation service, thus being a lot more open to alternative dispute resolution as a very effective means for resolving disputes. But it does take a while to implement a culture change. So I think that culture change and rules have to go hand in hand, but there also has to be opportunities for that culture change to happen. And the Civil Justice Council, looking at the system as a spectrum, which includes all tiers of the civil justice system, I think is the best way to encourage that change to happen alongside rules.
We'll move to David McCletchy now, to be followed by Hamza. David.
Thank you. Good morning, everyone. I suppose the public would look at all this and ask, well, is this change going to make the civil justice more accessible to people? Are we going to get a speedier resolution of cases? And are we going to have a reduction in the costs of resolving these cases and disputes? So I was wondering if you could tell me why the creation of this council is more likely to achieve that positive outcome than the sustaining the existing system of rules councils that we have. Well, maybe
I'll start with Ms. Wood this time, then I'll come to this one.
I think the perceptions of people who enter the civil justice system as users, as end users, so the perceptions of people who seek to address justice are often very different from the justice which they end up following. So somebody at the start of a process doesn't necessarily expect that when they have a claim against somebody who's not built their fence properly, they're going to be in a sheriff court standing in front of a sheriff and following all of the rules that go along with that. So I think in terms of streams of accessible justice, looking at the civil justice system as a broad spectrum will be the best way for people to be able to access justice in a much more effective way. So being able to have opportunities like mediation or like other forms of dispute resolution where they might be called for is not the best thing for every case, but for some cases it's certainly the best thing. There are some cases that should never make it as far as the sheriff courts. And I think the sheriff court process puts people off pursuing their civil claim if they're not supported by lawyers and professionals in the field. If alternative dispute resolution is embraced as much more of a cultural part of the civil justice system, then people's access to that outlet will be a lot easier. And then if their claim isn't resolved there, it can be referred on. I think one of the problems that we see in the service with the in-court mediation project in Edinburgh Sheriff Court is the cases have to be referred there by a sheriff, and then the case has to be closed in front of a sheriff. So while 80% of the cases are resolved within mediation, that is still a lot of court time that's spent on referring the case to mediation and then closing the case. So I think to take it a step further, if you let people access alternative dispute resolution at the earliest stage in their dispute without having to go before a sheriff first, then that's another barrier removed to people being able to access justice quickly and efficiently. Not in every case, but certainly in many cases that might end up before the sheriff court.
How would you do that in terms of this legislation?
I think we see the policy role of the Civil Justice Council as being something that would deal with that, that would deal with possibly the practitioners' preconceived ideas about what alternative dispute resolution is and can be, and we would see a a research function of, you know, possibly being able to commission research into how people access justice and how people's perceptions of access to justice has changed over the implementation period of the Making Justice Work programme. I think we envisage the policy function of the Council as very different to just being about rules, and we see that as a very, very important thing in maintaining access to justice for end users of the system.
But that's interesting, but not as a mandatory. I think Lord Gill said he wouldn't want it to be mandatory that there should be ADR before anyone comes to litigation.
No, and I
don't want that either.
No, but I think that's part of the culture change, which has to be looked at, and I think that is an important function of the Council to monitor the change in culture, so that solicitors do understand what alternative dispute resolution is. I have to say, I'm quite a recent graduate of well, in the last 5 years anyway. And I did law at university, and in my whole time there, I don't think alternative dispute resolution was mentioned once. So perhaps that's a place where a culture change could start in terms of letting law students know that it's out there and that courts aren't the only way forward.
I'm quite shocked at that, because I went to something about 8 years ago as Justice Convener there to Baltimore, where ADR mediations, you know, in major commercial actions actually. Yeah. Not just in family law and so on, because it saves, at the end of the day, you're going to have to agree something or somebody's going to win, or it's compromise, and saves everybody a lot of money.
Yeah, it just, I have to, when I came out of university, mediation was something that I had been particularly interested in, and so it's a subject that I pursued to expand my knowledge on, but it is something that wasn't at all mentioned in the course of my university career.
Well, Mr Conway, we'll not go down that track just now with the Law Society. It's for another day. Do you wish to come in here with...
I think the answer to Mr McCletchie's question, hopefully, is this, that there will be a single overarching organisation with responsibility for what are currently disparate strands. They're obliged to publish an annual plan. They are accountable to users in a way in which one has to concede the current Rules Council are not. And I think, just picking up on what Lord Gill said, they are the vehicle to implement the Gill reforms. So the answer is, do I think the Civil Justice Council will result in cheaper, better access to justice? It should do. It should do.
Mr Henderson.
Well, since you're talking about culture change, I don't feel the same trepidation about coming in. But you are talking about a long-term process and getting it right before you start. And if you start by saying we will have a Civil Justice Council, and you haven't defined what it is you're actually going to do as a Civil Justice Council, and if you say we're going to look at the rules and we're going to implement the Gill reforms, then you've actually got two competing policy objectives at the same time. One is narrow, were they vital, Gill implemented. The other one is achieving the culture change in the way in which justice is delivered in this country. If that is the road you're going down, then you might be able to put in administrative justice. In September 2010, the Ministry of Justice, Kenneth Clark, said that they were going to merge the tribunals and the uniform branch courts, judiciary, in England and Wales. We are still waiting for the consultation document on that, because it is a vastly more complex operation than may have been understood, and I think certainly was understood by the Ministry of Justice at that time. If you set up, and here I come back to the Ministry of Justice, if you set up a Civil Justice Council and then you want to tack on administrative justice, you're tacking one culture onto another while you're actually trying to change the culture overall. That, in our submission, would not work.
Yes, Ms Wood.
I think just to briefly follow on from that, that's something that we said in our submission, was that when the Civil Justice Council is thought about, it should be thought about in terms of the outcome of the Making Justice Work programme, not just this point in time. Because the outcome of the Making Justice Work programme will represent a very different civil justice landscape than the current one does, and it will include things like alternative dispute resolution. So to embed that culture, which we're aiming for, at the start of the very start of the council would be the best way to look at the makeup of the council. And so there should be people who represent interests such as alternative dispute resolution, so that that's embedded in the very culture of the function of the council from the outset, not just bolted on as and when it comes up as a thing in the civil justice landscape.
Ms Johnson.
Yes, just a very brief comment on the theme of culture change. One of the changes that this committee has to achieve is the change to ensure that court users are actually central to the process, because this is, after all, what it's all about, people going to court and being represented. So I think the change in ensuring that when all the recommendations of the Guild Review are actually processed, that court users are at the centre of it, and the Scottish Civil Justice Council takes this into account. And in relation to culture change, and I was very pleased to hear Hamza Youssef mention it, and thank you very much, about the issue of domestic abuse. Part of the culture change is recognising that it's not a dispute. So it can't be dealt with by dispute resolution. Domestic abuse is not an issue of two parties warring. That's not what it's about. It's an issue of power and control. And in relation to the culture change, and therefore involving court users, we have to be aware that, therefore, ADR mediation is not very appropriate in those particular cases, because it's just simply not safe. And therefore, where we have any channeling or triage or any process that would actually lead people towards going to mediation as a first opportunity, it should be made very clear that you don't have to do this. This is there. If you don't want to do it, you don't have to. And there will be no adverse implications or adverse kind of suggestion made by the fact you didn't want to use it. As you said yourself, Hamza, we have come across situations where it has been suggested or implied, inferred to women, that if they don't do this, then they'll be regarded as being obstructive, etc. What we want is a civil justice system where people feel they can access at the level that they want, and there's no punitive measures or adverse influence taken if you don't want to go down a certain course. And the whole culture change and mindset change will have to take that into account when looking at change to the justice system.
Is it not fair to say, heaven forfend, I paraphrase Lord Gill, but wasn't it fair to say that's why he didn't want it mandatory, there'd be ADR, because it's just not appropriate?
Yes, he did say not mandatory. However, it depends how you actually frame the system for the processes you have to go through in the first place. If it's there as an option, but not to be seen as something that you would automatically consider, even though it might not be mandatory, if there was almost a presumption that it would be considered as an option before you would do anything, as long as there was no adverse influence drawn from the lack of mediation or the reluctance to undertake it, well, that would be fine. And also a realisation that in some cases it is just not appropriate. It's the end product that we're concerned about. Whatever stage you enter the civil justice system is appropriate for you, and you're not considered that you should have done something else beforehand, before getting to that stage.
Mr. Conway, is that you wanting to come in there?
Yes.
I'm good at reading hand signals now. Yes.
Just very briefly on ADR to mirror what the Lord President said and what Lee says here. First of all, ADR is a whole range of possible scenarios: arbitration, mediation. One of the practical areas which I should have answered Mr. McCletchie is that there are pre-action protocols which are in existence at present for certain types of claims. And these are very successful, but they do not bite because there is no mandatory sanction on either lawyers or insurers to comply with them. And it's anticipated that the Justice Council would integrate these protocols into the rules so that there would be sanctions for failing to abide and comply with the protocols. As far as mediation is concerned, I will confine myself to saying that it is not the silver magic bullet that some of its proponents make claim for.
Hamza on that. You wish to come in now.
Thank you, Convener. It's not on that issue, though. I was interested to hear what was said, and I think it's something we will follow up quite robustly, or I'll certainly follow up as a member to see how it progresses. Actually, the discussion that has taken place between the panel members has been, for me, incredibly informative. Probably reasserts the maximum that the less the politicians talk, the more sense things seem to make. But the discussions that have flowed in my mind, especially the first half of your discussion, probably reaffirmed for me that the flexibility that is in here in terms of membership of the council is probably a good thing. But where you might have a particular issue, where I have a little bit of a worry and a concern, is if the makeup of the council, the composition of the council is to be, as is suggested in paragraph 6, then maybe there needs to be more checks and balances in terms of the Lord President and his power to be able to appoint. Although he has to consult with Advocate Law Society, Scottish ministers, I wonder whether or not you have an issue with the fact that there needs to be perhaps more democratic, if I can put it that way, checks and balances. And that leads to a wider issue about the role of the Lord President in general, which one of my colleagues earlier on brought up in the previous session about the general powers of the Lord President, disqualification, appointment, chairing of meetings, even setting quorum for a meeting, and whether that gives you concern. So the specific one about the composition of the council, and then a general question about the powers of the Lord President, I'd be interested to hear your views.
Well, you heard what the Lord President said. I might answer, Mr Yousaf, your question differently at a different time. As well as the challenges which have been outlined, I will not repeat myself as to what the Lord President has to achieve over the next 5 years. Here is the kicker: there is no money. So that we're asking him to undertake a colossal and extremely ambitious job, I think. For what it's worth today, and as I say, I may not give the same answer at a different point in time, because I do appreciate the points made by Mr Yousaf. Today I would say, let him get on with it, and we will put our shoulders to the wheel.
Did you haven't answered whether you thought, I think, which hasn't really been delved in, is there too much power in the hands of one person, the Lord President?
I don't think there is too much power in the hands of this Lord President, is what I am saying at this point in time.
Thank you.
Yes.
Ms Wood.
I was pleased to hear the Lord President talk earlier about the public appointments process, and I think that does mitigate a lot of the concerns that we had about how the members would be appointed and how democratic that might be. In terms of the role of the Lord President, I think we do still harbour concerns about again, if we look at this council as a council which will stand in 40 years' time, we do harbour concerns about the fact that there isn't a great deal of separation of power between the Lord President and the Council. So for the Council to act as an advisory body, that advice will always be slightly compromised when the issues that they are that they're advised to look into come from the Lord President. I think this Lord President, there's not as much of an issue with that, because Lord Gill, I think, is the best placed person to be there when the council oversees the next 5 years of the Making Justice Work programme. But I think at the outset of the council, we can't be skewed with the thought that Lord Gill will be the Lord President forever. And there is always the chance that in years to come, the separation of powers will become an issue. So I think that is something that needs to be looked at again, certainly.
Yes, I do wonder if you there, I mean, just on that point, and me and another member of the committee were talking during the break, then I probably should have pursued it slightly further when the Lord President, who I agree with you, and there's a Lord President where perhaps there isn't as much concern and is wise, and there may not be as wise and benevolent Lord President as the current one, and we have to take that into consideration. But particularly concerned was when it was discussed that the Lord President made, and I don't wish to quote him unfairly, but suggestion that if his opinion or the Lord President's opinion diverged from the Council's opinion, then that would present an issue. Whereas that to me says, well, or suggests that there may be assertion of one's opinion over the other, certainly the Lord President's opinion over the Council. Did you share that concern, or was I misreading what was being said by the Lord President?
I think it is a concern, particularly with the range of powers that the Lord President has in relation to this body. Again, I don't think it's something that is fair to judge on the person at this time who is the Lord President, because he is the one who is best placed, I think, at the moment to lead this programme. But yeah, I do think that there is a concern about whose opinion will prevail if the independent advisory is advising their chair one thing and their chair is the person who's making the decision. I think one way to possibly get around that would be not just presenting reports and recommendations to Parliament, but also presenting them to Scottish Government ministers and requiring Scottish Government ministers to take account of the recommendations that are being made. So it's not just the council who, and this kind of goes back to our interpretation of the policy function of the council. So if the council are looking at policy in terms of the policy relating to end users and that sort of thing, then to take the independent advisory function a step further and present their advice to the people who are actually making the policy.
Yes, that's very interesting.
Mr. Henderson.
When the Tribunal's Courts and Enforcement Act was passed in 2007, it followed on the Leggett report. The Leggett report said the primary interest in tribunals and in the Ministry of Justice should be the user. If you are trying with this bill to implement the Gill reform, then the most efficient way will undoubtedly be for the Lord President to chair and deliver that reform. If, on the other hand, you are looking for the culture change in a broader policy context, as far as civil justice and its development is concerned, then placing the user at the centre, as it is in administrative justice and tribunals, becomes, in our view, essential. And that means that you have to have something which is separate and distinct from the Lord President. He would do, I'm absolutely sure, I'm not saying this, he would do the job properly. And it is simply the niceties, the appearance that we're talking about, really. But if you are putting the user at the centre, then putting the user at the centre of this means that you have a structure which is separate and distinct from the courts, rather than being led by the courts.
Yes, Ms Johnson.
I would like to echo the concerns and the comments by my three colleagues here. Firstly, in terms of representation, the Lord President was very clear to say that it would be appropriate to consider which spread of interest groups are appropriate to be considered in the public advertisement of the process, and therefore to sit on the council, which is absolutely right. Now, that is the view of the current Lord President. But we cannot ensure, without some sort of safeguards written in, especially to the membership of the committee, that we would always have such an enlightened view, and court users, as Richard said, would be regarded as being central to the process. So for that reason, I think it would be preferable that the up to other 6 persons considered the LP members certainly should be court users, lay members, representatives, to give a better spread of representation. And certainly we would be, as I said, we would echo the concerns that whilst the current Lord President is being very open and inclusive about this, we have to make sure that future Lord Presidents and the running of this committee, the focus of this committee and how it will report, will be equally democratic. And this, I think, therefore, underlines how important it is that it should report to ministers, be accountable to ministers and Parliament.
Well, I'm going to, yes, thank you. I've got quite a list, and it always happens that you accelerate just as we're going down. So I've got Alison, and then I've got Jenny, and then I've got Graham. I want to take Alison because you've been waiting a long time, Alison. Hamza, have you concluded? Thank you, Alice.
Thank you.
Yeah.
Well, just to pursue the issue of administrative and tribunal Justice Council a little bit further, and I know that Lord Gill and indeed Mr Henderson yourself have alluded to perhaps it's premature to discuss these matters, but there's a real danger if we don't talk about it that there might be a vacuum, a gap might be created sometime in the future, and if that was so, do we need a mechanism in place in this bill that could trigger something in the future? And perhaps more fundamentally than that, are the two cultures actually incompatible? I'd be interested to hear from other panel members as well as from Mr Henderson as to whether that's the case or whether there are benefits to be had from both of these organisations being under the one umbrella.
The cultures are different, but that doesn't mean to say that they are incompatible. The old cliche about one being inquisitorial, if we went on to talk about tribunals as opposed to courts, one being inquisitorial as opposed to the other being adversarial, it's better to see things as a spectrum, because in the middle of that you've got employment tribunals which are in effect, although Shona Simon probably wouldn't forgive me for this, courts by any other name. They're adversarial with a highly legalised procedure. On the other hand, if you went to the private rented housing panel or things like that, then you're dealing with things which are much more user problem resolution focused, where the tribunal will, as it were, get their hands dirty in trying to solve the problem. So there is a spectrum, as in all things, but it underlies perhaps the culture within a tribunal is, I think, to solve the problem. The culture in the court is to resolve the dispute as it comes to them on the basis that it's brought to them. So one is seeking to resolve something, the other one is seeking to take the pleadings as they're put and decide it on that basis. And if your pleadings are wrong, then justice may be on your side, but you're not going to win. In a tribunal, one hopes that if justice is on your side, then you'll win. So there's a cultural difference at that level between courts and tribunals. There is a cultural difference in the sense of the formality or informality of the proceedings. But again, that's not a permanent situation, not a question of incompatibility. If you're getting beyond the kind of courts and tribunals into the administrative justice area, and you're talking about policy, then the nature of the policy you're talking about in there is, I think, quite markedly different to what you would talk about in a Civil Justice Council context. Because the focus of administrative justice is on the citizen and the state, of necessity, a body that is looking at that relationship is looking at the position really of the powerless against the powerful. It is looking at issues which do have a political overtone. Let us take, for example, recent examples from the South. A decision by the Home Office to withdraw the accreditation of London Metropolitan University has an effect on the university's power, its ability to undertake its function, but it has a marked significant effect on the position of the individual students. Now, their position, therefore, is as a consequence of an administrative decision which was taken in relation to a different set of circumstances. If you take the position perhaps slightly further removed of, again, in England and Wales, the current difficulty in relation to the examination diet, it is perhaps, from one point of view, slightly disturbing that the criteria, if this be the case, that the criteria upon which examination awards were to be made was altered during the course of a current year. Now that takes you into what are the principles which should underlie the operation of the administrative justice component in the decision that's taken by that examination board to allow to. So you're getting into the question, how is it that an examination board came to think that it could do this sort of thing? And I'm prejudging it most awfully, but on the basis of what I understand to be the situation. It becomes a significant and really quite political issue. Now, courts are part, you take your classic separation of powers, executive, legislature, and the courts. That separation allows the courts to deal with what's happening in the courts, but don't expect, I think, the courts to come out of that and begin to operate within the area which is the executive. Administrative justice, it requires you to begin to look at that interplay of how the government actually works in quite detail, quite a lot of detail. So there is a real cultural difference at that level between civil justice and administrative justice. Now, is that making any sense to you?
Thank you.
I'm thinking we should be keeping them separate, but I think it seems so completely different, administrative justice from court process and court rules.
Again, I think at this particular stage in development, then to put them together is putting them together on a hope, a wing and a prayer.
Yeah.
Until you've analysed what it is that what the differences are, and are these differences fundamental? In some areas, they are utterly fundamental. In other areas, they are cosmetic.
I think it's the political implications that follow from these that make it sort of incompatible in a way with the depoliticisation of courts, in a sense, which is... can I move on to... I'm losing my track now. It's Jenny to be followed by Graham. You've finished. Right.
Very quick question, if that's okay to all of you. The senior public law professors of Scotland have recommended that the deputy chair of the council be a lay person. Do you agree with that proposal?
I think that was something that we had in our submission. That certainly, at least the opportunity for the deputy chair to be a lay member would be a very positive thing in maintaining the user interest.
Thank you. Mr. Conway.
No particular views on the matter. I keep on going back to the same kind of chorus. I'm content that the current Lord President resolves these matters. If that were to be the view of this, if this committee were somehow to take comfort from the deputy chair being a layperson, I would not have any real objection to that. I would have to say on behalf of the Law Society.
Ms Johnson.
Oh, thank you. Sorry, I'm waving my pen here. Yes, I would agree with my colleague that the deputy chair should be a layperson. I think to take forward the spirit of inclusion, the spirit of consideration of court users' interests, and to affect the culture change that we have talked about, which has been so much a focus of the discussions today. I think to have the opportunity for the lay representative to be able to chair such a high-level committee, and to, I think, to be able to ensure that the discussions, I think, had parity. So there wasn't just an issue of rules, but also where discussions were looking at policy, procedure, perhaps legislation, etc., that court users were actually represented.
Mr Henderson.
Apart from that, if you're trying to signal a change in the future, signalling that the user is coming to the front, that is not in the hands of the professionals, then allowing the deputy chair, the vice chair, to be held by a lay person would be immensely valuable.
Graham, this will be the last question, I hope.
Yeah, thank you.
I shouldn't have said that. Nobody put their hands up now, please.
And hopefully a practical question. And the benefit of all you've said about the level of confidence you have in Lord Gill and some of the concerns you had about perhaps a future Lord President and their ability to match the wisdom of Lord Gill, do you think in order to achieve the kind of reform and move forward in civil justice that we should confine ourselves to what we've achieved in terms of the bill that we have before us and put a mark in the calendar to revisit circumstances 2 or 3 years down the road in order to see, first of all, how has this worked and whether or not we would want to insert some balance to take account that Lord Gill has achieved his reform, and these broader issues, these more philosophical issues, if I could put it in that context, could then be addressed at some future time, but put a marker down now that that needs to be done in case it's overlooked.
For what it's worth, I think that point's very well made, Mr Pearson. I think it's unlikely that Lord Gill's role or any Lord President's role is going to provoke any kind of constitutional crisis. But if it does, the persons in here, I'm sure, will be the first to know about it. And secondly, one would certainly hope that this committee would take an active interest in the progress of the Making Justice Work reforms.
Brief answers from panel members now, because I think I was seeing nods of agreement in the main.
I think we need to start as we intend to go on. So I think the reforms to the structure, to membership, to some of the powers and the functions should be implemented now, and we have the benchmarking in whatever many years' time, 5 or whatever, to see how it's gone, because it might look then that we need to actually say extend user membership or have greater use of committees and how the powers and the functions of the council actually operate. But I think as an indication of the intention, both of Parliament and of ministers and everyone who's involved in the process, to say that we intend to have court users, to have this to be an accessible, democratic and accountable process. I think all the suggestions that have been made should be implemented now.
Yes, last few words, Mr Henderson.
I think the staged approach is suggested by James Wolfe in the second submission from the Faculty of Advocates. I think that is an excellent suggestion. I think that this process is so complex that it has to be done in a measured and considered way over a period of time, rather than one big bang.
I think it's a very good suggestion as something to mitigate a lot of the difficulties we've been discussing in terms of the priorities that we each bring to the table. The one thing I would worry about in that is that it's been quite clear throughout the discussion that the rules-making function seems to be of primary importance at the moment, whereas the policy function seems to be something that would be considered later on. And the thing that I would really worry about was that the policy function got forgotten and buried underneath the rules function for the period until the councillors reviewed.
Well, can I thank you all very much. Thank you for your evidence. It's very helpful. Thank you indeed.
Thank you.
That concludes that particular item. I'm moving straight to item 3. Subordinate legislation, one negative instrument for consideration today, Pro Board Scotland Amendment number 2 Rules 2012, SSI 2012/197. While the Subordinate Legislation Committee has drawn the Parliament's attention to the instrument on the ground that it was not laid at least 28 days before coming into force, if I could just have people leaving more quietly, please. While the Subordinate Legislation Committee has drawn the Parliament's attention to the instrument on the ground that it was not laid at least 28 days before coming into force, it was satisfied with the Scottish Government's explanation for doing so. Do members have any comments? Are members content to make no recommendation in relation to the instrument? Now return to item 1 in the agenda, and I'll just for clarification take them separately. Can I take it the committee is invited to agree whether to consider items 4 and 5 in private?
Agreed.
Agreed. Now can I turn to item 6? And can I just for clarification, which part of my fault here is that we will be looking, the point here was that to have a look at our full work programme next week, because of course the government is coming forward with its legislative programme, so we kind of have to know what that is. However, in order to allow invitations to be sent in good time, the purpose of this particular item on the agenda is narrowed to agree to whether to hold an evidence session on the role of the media. That's the first point, because we've got a debate coming up on the impact of the media on criminal justice system. So the first point was the purpose of the item was to agree whether to hold an evidence session on the role of the media in criminal trials on Tuesday, 2nd of October. And if we agree that, whether we think that's a sensible thing, if we could agree the witnesses, because we really need to give people notice, particularly in certain areas of work, for the format of the session, and that that the actual consideration of the full work programme, and indeed the way we deal with the work programme, I would intend, with leave of the committee, to be placed on the agenda for next week. Now, Deputy Convener, are you content with that now? Because we're not going to discuss the full work programme, narrow it down to that particular issue. We will discuss the full work programme and indeed the way we deal with it next week.
Convener, if item number 6 is not a discussion of the work programme and is indeed a discussion of detail of witnesses that we're going to invite for a very specific thing, I'm happy for it to be taken in private.
Thank you very much. We therefore move on to item 6 in private now. And I beg your pardon, we don't move on to item 6. I'm ahead of myself, it's item 4, but we're into private session. That's where we are.